Good afternoon to you, to all. First of all, I would like to present Mr. Jonathan Marsh, who is President of the European Company Lawyers Association. Jonathan, you have the word.
Thank you. Thank you, Duarte. Good afternoon, everyone. It's really an honor and a pleasure to be here in this distinguished hall with all of your former presidents of the Lisbon or the Portuguese Law Society. I'm delighted to be able to say a few words about legal professional privilege to the LPP, which I will refer to it as, and about the DPO. LPP is really not as hot a topic, I would say, as European energy security or joint military defense that we're looking at now. But I really do think that LPP is an important strategic issue for Europe. We all know that the promotion and protection of the rule of law is one of the fundamental objectives of the EU, a critical element of its sovereignty. LPP is an essential aspect of the rule of law. It allows clients to share all information with a trusted legal advisor to obtain advice and counsel in full confidence. In the same way, DPO is becoming a significant topic for companies in Europe and for the legal department as we grapple with the challenging aspects of implementing this role. So I'll start with a few comments on DPO, and then I will turn to LPP. So the data protection officer must be appointed under Article 37 of the GDPR if the core activities of the controller or processor consist of processing operations which require regular and systematic monitoring of data subjects on a large scale or processing a large scale of special categories of data. This is quite a broad and somewhat vague definition, I would say. But we do have the Article 29 working paper, which provides some clarification and guidance. We'll get the impression that there will be essentially two extremes with clear answers: the individual or small-scale enterprise, or the global multinational operators. However, most businesses are going to fall somewhere in between. Companies need to focus on scale, the strategic core importance of the data, and the regularity and systematic use to determine whether they need a DPO. Let's assume that you do come to the conclusion that you need a DPO. How do we appoint the DPO? Do they have the requisite data protection knowledge? And for those in the room, the in-house counsel, can the DPO be a general counsel or another internal lawyer? There's no clear answer to this, and it's a little bit troublesome insofar as the failure to appoint a proper DPO can result in fines, the higher of 10 million euros or 2% of worldwide turnover. The role of the DPO is to ensure compliance with GDPR. This is not just an examination of the legality of a particular topic. Rather, the DPO has a broad role to be involved properly and in a timely manner in all issues relating to the protection of personal data. That is an advisory role. There's also a supervisory role, more like a compliance function, to monitor compliance with the laws and the internal policies of the company. The DPO also serves a role of training internal teams and being the contact point for regulatory authorities. In this role, the DPO is bound by confidentiality regarding the data and any confidential information. The DPO also must be completely independent and cannot be dismissed for making recommendations contrary to the management's preferences. These questions of confidentiality and independence tie in with the LPP topic. If I am a DPO in France, for example, and I'm also a general counsel of the company, there seems to be a legal conflict. How can I be deemed independent and have confidentiality rights as a DPO, while at the same time French law considers that a general counsel is not independent and has no confidentiality rights? So given all that, who can be the DPO? The description of the position is really quite impressive. So many qualities are required of a DPO, so much so that it may be impossible to be an expert in the legal aspects and the operational aspects of the DPO. But the aid 29 WP allows for the knowledge and ability of the DPO to be either his own personal knowledge or that of his team. So we can come to a realistic and I think a useful compromise position when selecting a DPO. If we decide to appoint a general counsel or a managing lawyer as DPO, we need to take special care to ensure that conflicts of interest are avoided or dealt with appropriately. For example, if a pure legal advice is required, the DPO should refer the matter to others within the legal department. He shouldn't be involved in providing legal advice on the regulator's position, for example. It's probably good practice to make an official letter of appointment to set out roles and responsibilities and giving practical details on how all the statutory obligations will be satisfied and how conflicts of interest will be dealt with. You might also start by having two separate email addresses for the person if he's serving in two roles. So I don't know about you, but I would certainly want to have a good directors and officers policy in place if I were to serve as a DPO. So now let's turn to LPP. So as I mentioned, this is really a fundamental aspect of the rule of law, which we believe at ECLA should apply equally to in-house counsel working within companies and also external lawyers working in law firms. This will protect the rule of law within Europe. And from the sovereignty perspective, this will ensure a level playing field and fair competition with jurisdictions outside of Europe and among countries within Europe. Now, we've done some research and we've found that LPP is currently accepted in most EU member states and in a majority of OECD countries. And yet significant exceptions persist in Europe as a whole, and particularly in major jurisdictions such as France and Italy. At the EU level, LPP has been especially restrained for internal lawyers in the realm of competition law. These exceptions weaken the rule of law in Europe and adversely affect its sovereignty and competitive position. The freedom to choose a trusted lawyer is inherent in the fundamental right to a fair and public hearing before an independent and impartial tribunal, as set out in the ECHR. But these principles do not distinguish between internal and external lawyers. European jurisprudence has taken a different view, notably in the AMS and AXO cases, and we believe that these judgments are misguided and clearly out of date. Europe is increasingly alone on this topic as compared to other OECD members and the UK and the US in particular. Companies operating in EU jurisdictions not protected by LPP run the risk of having their in-house legal function, legal opinions, seized by foreign judicial authorities in criminal proceedings or by foreign civil opponents in discovery practices. And these disclosures can result in disastrous legal, financial, and reputational consequences for EU companies, and also provide adverse political and sovereign impacts, legal credibility, and economic competitiveness. So our multinational companies are subject to an increasing body of laws and rules and regulations in a large number of national and supranational jurisdictions. Management needs competent legal advice on short notice on a range of complex questions. In-house lawyers perform the role of compliance gatekeepers in this context. And if we don't have generalized LPP for in-house lawyers, companies with operations in the EU must choose between moving their legal department into an LPP favorable jurisdiction or staying in an unfavorable jurisdiction, but relying more on outside counsel with higher costs and reduced efficiency and competitivity. And then there's also the specter of companies not seeking legal advice at all because they say, well, we've exhausted our legal budget and we don't have the financing to seek that legal advice. This would be hurting compliance efforts and also increase legal risk for our EU companies. And there's a risk of loss of strategic head offices to jurisdictions outside of the EU, which can adversely affect our independence, sovereignty, and competitivity. Now, all of these risks were well documented in a parliamentary report in France a couple of years ago, led by Raphael Gauvin. And this Gauvin report observed that due to all of the risks that I mentioned, French companies actually refrained from requesting written opinions from their in-house counsel, which weakens the legal department and excludes lawyers from some strategic decisions and discussions. The Gauvin report strongly recommended the adoption of LPP for in-house counsel in France, but the recommendation was not followed due to very strong opposition from enforcement and regulatory authorities, and who were concerned about the black box risk in companies, and also from the private bar, concerned about the growing strength of the in-house legal profession. On the regulatory front, I believe these concerns are completely unfounded and show a misunderstanding of how LPP works in practice and how it's treated in other OECD countries where LPP is protected. In common law jurisdictions, for example, in-house counsel have LPP and is viewed as a pillar of the rule of law, even in the antitrust enforcement context. Now, the French Competition Authority recently issued some draft guidance on competition law compliance programs. They issued this, their recommendation for the guidance for comment, for public comment, and the American Bar Association and the OECD both commented, specifically expressing concern over the situation in France, over the fact that LPP is not allowed for in-house counsel and how that could adversely affect compliance programs in companies. Regarding the private bar, I think their concerns are also unfounded. It's true that the in-house legal profession is growing, but in-house counsel are complementary to outside counsel. We generally don't seek to represent our clients before the courts. And a strong in-house legal department embedded in the business is far more likely to identify technical, innovative, and sophisticated legal issues and seek the advice on those topics from external counsel. These issues might not have been otherwise identified by operational personnel in the company. It's really the in-house legal that will identify these issues and then seek counsel outside. Then on the danger to sovereignty, the Gauvin report cites several cases where French companies have been charged with violations of foreign laws with extraterritorial application, such as the FCPA. An example is the acquisition by General Electric of a business unit of Alstom following accusations of corruption that were investigated by the DOJ. And as part of the settlement, concomitantly with the settlement, Alstom this business unit was sold to GE in a very weakened position. So there is really no level playing field in countries, comparing countries like the US or the UK with France and Italy. We can see how these investigations can be devastating and have strategic adverse impacts on the EU. And the extraterritorial laws and legal proceedings are being wielded in increasingly effective forms as a weapon, some kind of an economic warfare weapon. And lack of LPP protection is not the cause, but strong LPP protection for EU companies would at least allow EU companies to defend themselves on a level playing field and prepare more effective compliance programs using LPP. I'd like to emphasize that the profession and role of in-house counsel has also evolved significantly in recent years. As the regulatory and legal frameworks have become more complex and international, we see new professions arising in areas that are of strategic importance with extraterritorial effects, such as compliance, sanctions, export controls, supply chain due diligence, and maintaining control over data and cloud issues. And now we have even ESG coming along. So I think the time is right for initiating a reform movement at the European level to clarify LPP in the legal profession. Significant changes have occurred since AXO and AMS, both within the EU and in the EU's and its members' interactions with the rest of the world. And this evolution amply justifies revising the position of EU law towards protection of confidentiality of legal communications of in-house lawyers with his or her clients. We're in a world of increasing global competition, Among states, law has become an economic weapon, and I think there are sound policy reasons for protecting in-house legal advice, including the need to ensure efficiency of internal legal advice and the promotion of a robust compliance culture within organizations. As a result of the current disparity and the lack of legal certainty, businesses face unnecessary costs, administrative burdens, and comparative disadvantages within the EU that additionally have a chilling effect on the efforts to comply with increasingly sophisticated regulatory frameworks. So in conclusion, given these observations, I would argue that this is the right time to open a dialogue between member states and the European Commission to assess whether a new European legislation to protect the confidentiality of communications between in-house lawyers and their clients should be proposed by the European Commission under its power to legislate on the establishment and functioning of the internal market or another legal basis such as freedom of establishment. Thank you.
Thank you, Jonathan. This morning we had the ECLA European Company Lawyers Association Assembly. Considering this opportunity to have here Marcos and David and share experiences and debate the main topics under discussion on corporate legal practice, Ordem dos Advogados, in a joint organization with Instituto dos Advogados da Empresa e Associações and ECLA, decided to promote this conference. I would like to thank the generosity of all speakers who promptly accepted this challenge. Thank you, Marcos. Thank you, Pedro. Thank you, David. And thank you, Tiago. And thank you, Jonathan, as well. So I will begin now the first panel. We will have Pedro and Marcos. Pedro is a well-known Portuguese lawyer, chairman of the PRA, Raposo de Miranda e Associados. He is managing partner of this law firm. Founded Pedro Raposo and Associados in 2001, correct? And played a decisive role in the merger of this law firm with Sá de Miranda and Associados and Almeida Correia, Neida Costa and Associados, leading to the current PRA. Since 2011, he is president of the Portuguese Task Force on Green Economy and International Chamber of Commerce, right? Okay. Marcos is the general manager of ECLA, and is also internationally experienced manager in the legal services industry with broad commercial and business experience, innovative mindset, especially in the digitalization and legal operations, proven managerial, political, diplomatical, and communicational skills, and the right can-do attitude. Right? Okay. One of the topics in today's ECLA General Assembly was the LPP that Jonathan just spoke, the legal professional privilege. In Portugal, a lawyer who practices his profession under an employment contract on the premises of his employer, appearing on the list of company's employees, does not lose his quality of lawyer or the faculty to exercise the profession with the deontological values that it requires, applying the rules of the legal professional privilege. But Marcos, this is not the scenery in all Europe countries, right? Can you give us a perspective of the general panorama in Europe, please?
Thank you very much, Duarte. I hope you can hear me quite well. First of all, I would like to thank you and Ordem dos Advogados for the possibility to speak here today and to have this conference on professional secrecy, which obviously is a very, very important topic for us lawyers. It is important in Portugal as well, but not as challenged as it is in other countries, obviously. And we are very happy here to cover a little bit on the European ground today to give you also an understanding of how legal professional privilege works in other countries and how it does not work in other countries. So maybe starting from the best case scenario, which Portugal is one of the countries that has these best case scenarios. Normally, there should not be a differentiation between external counsel and in-house counsel. We all visited the same law schools. We all did the same kind of education. We all do the same job. We advise our clients, may they be internal or external. So there should be no natural differentiation. However, in some countries there is. Portugal does not differentiate. All the members or all the lawyers are members of this institution here, this organization, Ordem dos Advogados, if I pronounce this correctly. I'm always happy to learn some Portuguese. The same refers to other countries in Europe, especially the common law countries like, for example, England, Wales, Scotland, Northern Ireland. Ireland itself, so the law societies that are the regulation bodies in these countries, they do not differentiate between in-house counsel and external counsels as well. They're all solicitors or comparable or barristers, no matter if they work internal or external. The same refers to Spain, for example. Norway is another country where there is no differentiation. And two other examples where there is no problem existing is Poland and Greece. Those are also all member jurisdictions of ECLA, of the European Company Lawyers Association. And then on the other hand, and that's really the big opposite, you have countries where there's absolutely no legal professional privilege for in-house counsel. Even countries where the profession of in-house counsel is not even recognized by law. One of the countries Jonathan just spoke about, this is France, very active in lobbying and advocating for, but the downside is if you work for a law firm in France and you change your job and you work for a large French company like Renault or Carrefour or anything else, you're even forced to leave the Bar Association and you cannot be a member of the Bar Association anymore because the law says, well, you decided to work not in a law firm anymore, therefore you cannot be a lawyer any longer. So the law doesn't know this. Obviously, our French colleagues, they highly advocate for this to be changed, but this is a long way down the road, obviously, in many jurisdictions. Other countries like Italy, I think it's very similar. We have some recognition in Italy for the company lawyers, but no legal professional privilege at all. Austria is another example, and many other small countries as well. Then we have a segment or a group of countries that recognize company lawyers or in-house counsel as a profession. Like, for example, in Germany, there's even a title for that, but still they're not granted legal professional privilege, at least not the full-scale legal professional privilege. They, in some countries, have some sort of legal professional privilege, like in Germany, they have it in civil law cases, but in the real big cases like investigations, antitrust investigations, even criminal investigation, there is no professional secrecy or professional privilege whatsoever, even not in Germany. Our German colleagues as well are highly active in trying to change that, but again, they have tough opposition there from various aspects, and we can speak about this opposition in a minute as well. And then there is also a small group of countries in Europe that has a special way, like I always like to say. Those are countries where there is a differentiation between company lawyers and external counsel, also in terminology, but they have full recognition and full legal privilege. But those countries solve the problem by establishing an individual bar association just for company lawyers. Belgium, for example, is such an example. They have a bar association that purely focuses on company lawyers, and they're only granted legal professional privilege and also the title of juriste d'entreprise when they are a member of this particular bar association. That's well, you can say fairly new law. It's not. It's since 2000, but that's when the Belgian colleagues gained recognition legally as well. Another question on that, or shall that? Okay, well, I mean, so we have, of course, we see a lot of activity by the member countries to change that. Legislative activities as well as activities with other stakeholders, especially colleagues. Where is the opposition coming from? And Jonathan touched upon this already. In most countries, the lawmakers or the ones that oppose legal professional privilege always refer to the very same judgment by the European Court of Justice, and this is the Axo Nobel decision, as you might know. And even before that, there was the AMS case. So the AMS decision was in 1982, and for the first time touched upon the fact that company lawyers should be handled differently than external counsel. And then in 2010, that was renewed by the Axo Nobel decision, where again, the European Court of Justice said, wait a minute, company lawyers cannot have legal professional privilege. With the sole argument, they said they're hired by a company. So naturally, they cannot be independent. But the core principle of professional secrecy and legal professional privilege shall be that the lawyer is independent. We know that we are all independent. We all consider ourselves independent. However, there are two things that always struck me, and maybe struck me because I'm a newer generation and AMS basically was a decision when I was born. One thing is that this decision itself did not have the broad scope that it is being interpreted today in, because it only focused on antitrust matters on a European level, so only investigations by the European Commission. This is where it said it cannot be independent. Nowadays, those countries opposing legal professional privilege for in-house counsel use this justification in order to say no legal professional privilege for in-house counsel whatsoever. So this is, in my case, they really extend the meaning of this judgment way too much. And then the second thing is obviously that the pure fact that company lawyers cannot be independent because they're hired by a company, to me, doesn't make sense as well. Because if you look into big law firms, what do law firms depend on? They depend on their clients. And there are law firms that have, I don't know, 1,000 clients, but there are also law firms that heavily depend on only a handful of clients if it comes to their revenue. So we can really start a discussion here. Does that mean one can be independent because he has 2 clients and the other one can't because he only has 1 client? That doesn't make sense at all to me. And I think this is why it's very important to do what we lawyers can do best, to structure the thing or to slice the meat in a way that we say maybe we have to break up independence. Maybe we cannot use the term independence as broad as it has been adopted by the European Court of Justice back then. Maybe we should differentiate and say there's a disciplinary independence and there is a independence in terms of contact, in terms of daily work. I grant, and given that company lawyers are not independent disciplinarily, that's, I think, a fact. The company can basically say you have to work from 9 to 5, you have to work 5 days a week, you have to work in Lisbon or in Porto or any other place. That's okay. That's a disciplinary independence, which we don't have because we decided to be hired by a company. But it could also apply to a hired lawyer in a law firm, where the partner of the law firm says, wait a minute, you have to be in the office at 7 because I need you at 7. And then I want to see an independent lawyer saying, no, I'm independent. I come at 10 and I go to Starbucks first. I want to see that. And the second level of independence is obviously then the independence of the actual legal work. And there, I think there is no differentiation between company lawyers and external counsel, because, as I said, we all have the same education, we all have the same background, and in most countries, we even swear the same oath once we are registered with a bar association, and that is to protect the Constitution, to protect the law, and to protect all the regulations around it. And no matter if you have this 1 client or 2 clients, you will always find out as a lawyer what is the right way to do it, to comply with the law or not. And I have never seen that somebody will break the law in a way just because he has been forced to do it against his will in a company, because that's what the company basically hires an in-house counsel for. They want to have the legal opinion. They don't need somebody to say, yes, that's exactly right, we do it the way you want. No, they want somebody to analyze what's the legal way to do it. How do I reduce my risk? Because that's why you hire a lawyer, otherwise you don't need to do it. And this is why there is a factual independence for in-house counsel in companies as well. However, it's still used today as an argument against company lawyers. And well, now going into the present time, into 2022, and I mean, we're at the end of 2022, almost 2023 now, we also have to recognize that the profession changed a lot. Not only the profession of company lawyers, but also the profession of lawyers per se. Our profession evolved a lot. Our profession is 2,000 years old, roughly 2,000 years old. And the last 20 to 30 years have been an enormous speed in change. And why is that? Well, of course, we have the European Union. We have tons of regulations coming out of this every day in terms of harmonization and terms of making all of our lives better as consumers and as well citizens of the European Union, there's regulation. And this regulation has to be adopted by companies. And that is why they need lawyers. And this is why we see a significant increase in our profession in terms of numbers, especially in the segment of the in-house counsel. Just to state a number, that's an ECLA number that we researched in the last 2 years. If you look into the growth of company lawyers all across Europe, today we estimate that we have roughly 150,000 company lawyers in Europe. There's 1 million lawyers overall in Europe, and we have 150,000 company lawyers. The number of lawyers overall in Europe is stagnating in the last 2 years. I don't know about Portugal, but most countries I looked into is the number of lawyers stagnates or even starts decreasing now. This trend will even increase in the next 5 years, is my estimation, because of the retirement of the peak baby boomers. So every large country you look into, the number is stagnating, going down. However, the segment of company lawyers is growing exponentially, and that's why you still see an increase of lawyers overall all across Europe. And maybe that's the same in Portugal, that the overall number is increasing because you don't differentiate between in-house counsel and not. If you look into the statistics of companies, only 15 years ago, the average number of company lawyers per company was 2.1 company lawyers per 1 billion of revenue. That was the KPI in Europe. Today, this number is at 4.9, and that's only 15 years later. And if you see that the number doubled, and you also take into account that this is a number that reflects a KPI based on the revenue of companies, and then you take into account that the revenues in the last 15 years increased as well, the GDP overall increased as well, then the actual growth of company lawyers in Europe is 165%. That's a 2.5x in only 15 years. And there you can see what the regulation, what the increasing regulation in Europe does with us and does with our profession. There is a high need for company lawyers in those companies. And this is, I guess, what brings us together here today to discuss professional secrecy, because it does not only make sense as a company to hire tens of company lawyers, or maybe even hundreds of company lawyers if you're a large company. You need to equip those in-house counsel with the right means to do their work. And if you look into all this regulation, then you can also assume that the governments in the European Union expect compliance from the companies. Well, if you do regulation, you want them to comply with those regulations. And in order to comply with those regulations, you don't want them to, first of all, break the law and then comply in the afterwards. You want a proactive approach of the companies when establishing new business models, for example, to check right in the beginning, is this legal or is this maybe illegal? Is this a gray matter? Is this something that we actually can do? And for this, you need a good system. You need a trusted advisor. And we all know it only works with open and transparent communication if you have trust with the one you're talking to. And if that person in your company is not equipped with professional secrecy, then I would doubt that a business manager, a CEO, or anyone else would like to inquire in their legal department if we can do that or not. Everything they say can be used against them in a court. I mean, we all know the movies. So I think this is why professional secrecy is one of the main aspects and one of the main toolkits you need as a company lawyer. And again, the number is growing, the demand is high, but the right toolkit is not being provided yet on a European level. And this is something we need to change drastically.
Stuff to the table, so to manage that, I will now ask Pedro. In Portugal, as we said before, there are no distinction between the in-house and external lawyers. So independence, responsibility, and technical autonomy are the foundation of being a lawyer. How is this compatible with the duty to legal subordination that exists when the lawyer is an employee?
First of all, thanks for the invitation. Happy to be here. And after what I listened, happy to be Portuguese and Portuguese lawyer, because, well, I'm here between colleagues. And the truth is that we are all colleagues. Nevertheless, we are lawyers in companies, lawyers in law firms, and individual lawyers. And I think the main question, well, you have one question regarding LPP that is that affect all of the lawyers, and that's related with questions as compliance, as laundering, even the questions of DPOs. And regarding, but before this, you have the question of the independence, and that is the main question that justifies the LPP, in my opinion. And naturally, it depends on the companies, but it depends also, as you say, of the lawyers, because one of the best things in my day is the capacity to say no when I don't like, when you don't feel that makes sense, it's not viable, I say no. And that's the most important thing that we have in our activity. And I think that naturally we'll have this independence in all the different forms of exercise our activity. If you are in a law firm, if you are in a company, naturally in the day by day it could be more difficult. For example, if you are in a law firm and you have the client that represents 80% of your invoicing, that could be a problem. It's clear that it will be more difficult if you are in a company and you are saying to your CEO that it's not possible to do it. Or if you are an individual lawyer and that guy will be the most important client for the next 2 years, okay? But that depends on the reliance of the lawyer. That is an obligation that we have in our activity, nevertheless the place where we are. And naturally we have good examples, we have bad examples, but the rule could not be made for the bad examples, that's for sure. Like that, I agree with you with the question of the independence. The problem that we have today in Portugal is when you mix the things. And well, I've been the other activities that I had in the past. I was president of the council for the surveillance of the practice of the lawyers in Lisbon. And in that time, there were some public cases, some situations that you have, where I saw the lawyers mixing the things. Imagine that you are a company lawyer, but in some moment in the time you accept to be a member of the board. You could not have both protections. If you assume to be a member of a board, naturally, the decisions that were made, you take place there in the board, with you acting. You could not say, well, in this case, I am protected by LPP. And most situations that I saw in that time were situations where the lawyers mixed the positions. Different situations you have today when you mix the activities. For example, if you have the Department of Compliance in your company and at the same time the Department of Legal, I think you have a problem there. Because in the end of the day, the obligations that you have, mostly the obligations of communication to the public entities, they don't work well with the LPP. And that's the problem that you have in the day by day. Like that, I think naturally there is a pressure for the authorities going to the email or to the office of a law firm or a lawyer of the company that is well organized with all the information that is easier sometimes. It's easier to do it naturally, but sometimes we put in the position that we don't want to be. And that is the thing that I think is most important. If we want to have the LPP, naturally we must be aware of the rule of the independence. That is a right, but is an obligation also. And in the same time, we must say no, not only to the treatment of a special case or to the instructions to do the treatment of that case, but also to assume different type of positions in the company. That's more easy in huge companies that you have significant division between compliance, legal, data protection, whatsoever. It's more difficult in small companies when you have a lawyer that assume everything, and that is not possible. That will put in danger the lawyer, that will put in cause the LPP of the lawyer, and that even could generate in the authorities the reasons they want to attack the LPP. Because that's not doubt in the world that we live today. And if you see the recent decisions of Commission and all the regulatory authorities, LPP is always a problem and the question they want to solve. And we are responsible today for still having the LPP in the future. And that is a part of our act in our days. We must be responsible when we assume the positions. We must assume positions that don't create this conflict of interest, because if you do it, probably will affect the LPP for the future. And that's the main concern that I have. Sometimes I saw when we are talking about the companies, when the different apps, let's say like that the people use in the day, put in cause not only their independence, but also the position of the lawyer, and naturally the fact that you have the grant of the LPP, that naturally is more important for the company, because if you could not talk with your lawyer, being your lawyer internal or external, and grant that what you are saying to him is not protected, that will be a problem, and probably in the end of the day will not talk naturally.
Marcos, I've seen you taking a lot of notes. Do you want to say something?
So Pedro, thank you very much, but you raised two very important points, which I would like to emphasize on again a little bit as well. You said we as lawyers have the right to say no, and I think this is a very important right that we have and that we learned on first day at college, at university, or at law school. This is our right to say no, and this is what we are paid for as lawyers. And you also mentioned that the argument by those opposing the secrecy for company lawyers are always bringing, yeah, I want to see somebody who's hired in a company to say no to his CEO. He does that once, right? But maybe we should say that, no, that's not possible. That's what you say is our right to say. No, that's not possible. This is something for the in-house counsel of the past. Because if you say, no, that's not possible, then you don't have a problem in terms of your CEO might fire you because you cannot say no to him. No, he might fire you just because you are a terrible in-house counsel. Because our job description naturally is not to say, no, that's not possible. That's what we did 30 years ago, maybe. Nowadays, we say no, but that's the way how we can do it, to show the way how actually to comply with the law and to also pursue a business opportunity or a new business model or something like that, to be the enabler. So naturally, I don't even see the risk if you're a good company lawyer that you have to say, no, that's not possible, because there's always a way to make it possible somehow. That's maybe one thing that we also should always reflect on when we argue as in-house counsel. And the second thing is, you said that we have to be a little bit careful in order to not put, if I understood this correctly, LPP under scrutiny for everyone, that we have to look a little bit into the segmentation of persons that maybe persons that hold various different positions in one person. Like, for example, a small company that has only one in-house counsel, and that in-house counsel is general counsel, he's DPO, he's compliance officer, he is whatsoever. You're right, there has to be a segment, but I would like to also mention here that LPP or secrecy is not the right of us as a lawyer. It's the right of our client. And we therefore, because it's the right of our client that we are not talking about what we had in communication with them, you should always look into LPP to be elaborated on a case-by-case basis. And doing that, you always have to balance, is that legal advice or is that business advice? And as a company lawyer, of course, you have a more blurry line that maybe an external counsel has in terms of legal advice or business advice, because company lawyers from time to time might also give business advice. And I think we can all agree on the fact that business advice is nothing that should be covered by LPP because it's purely business advice. And if we say, yeah, the chocolate should not be €5, it should only be €3, that's not covered by LPP, obviously. So this is why I think when talking about LPP is not about granting LPP to everything a person that belongs to a specific profession says. It's more about who's the client behind it, what's the interest of the client, and is that to be covered by LPP or not? And by doing this, you always have to differentiate between business and legal advice.
Well,
You make it easy.
two or three different things. First, I rely on the independence of the internal lawyers. I already saw in several times in my activity, they saying no to their client, and that is a fact. The second, and like that in the first question we agree, in the second one we disagree, and I will say why we disagree. When you have an evaluation about the LPP, as you say, we have the evaluation based on a case. And the worst position where I want to be is having some authority, having the possibility to challenge my LPP. Okay, I don't even want to be there. And like that, the recommendation that I do, having in accordance my experience, is never be in that position. Naturally, that a lawyer from a company discuss with his clients commercial things, but we also do it in the law firms, and the other lawyers also do it. Is not that challenge the definition of the LPP and the fact that you are subject or not to the privilege of the LPP. What's challenged that is when you assume different obligations, and that is a completely different situation. When I give the example that you are a member of the board, in that case, in my opinion, for the protection of your client and your company, you must cease immediately to be the legal of the company. Because in that case, it's not the authorities that are challenging the LPP, it's you that are challenging the LPP. The same way when you have at the same time the compliance of the company. Because the question here is, when we open the door, even a small part of the door, people go there. And that's the importance of our independence. One of the more important analysis that we must do to assess our client is assess ourselves. If you are putting in danger your client, accepting to have responsibilities that generate a conflict of interest, you are doing a bad job to your client, and you are putting LPP in risk. And that is my goal to when I talk about the different positions and the different acts. Okay.
I don't believe that we disagree there, actually, on this point. I think we have a great agreement on that there. Well, we definitely can agree on the fact that once you have a mandate, no matter if it is as an external counsel or an in-house counsel, and within that mandate, you will give advice, and part of this advice includes some business advice, you cannot start segmenting it into this miniature view that you started. This is covered, this is not covered, this is covered, this is not covered. No, of course. You were hired as a lawyer to give legal advice on a specific thing, so the entire thing shall be covered by legal professional privilege. No questions asked. Otherwise, we really get under scrutiny. But I was more talking about the case when you said that one person in a smaller company might have different job descriptions. For example, general counsel, and also he is the CFO or the whatever, he works in controlling, then obviously that part of his work, which might be half a day, that of course is not covered because that's not being hired as a lawyer. And then the second thing that you said, and now I think I lost what you said. Yeah.
Even in this first situation, my question is, you could not, or is difficult to separate when you are acting with a hat or with the other hat, okay? And in my opinion, in that situation, you are responsible to put in risk the LPP. Because it's difficult, and the first, don't forget the first question. I don't want to justify, to be in the position of justify. If I put myself, and we know the risky days that we live, we know that the lawyers are not very well seen when we are talking about these big procedures. And the question is, we must not bring the risk to this house. And if we do it, if we mix the things, we bring the risk to here, and to us and to our clients. And when you live in a world that is more regulation, more regulation, more regulation, more compliance, more compliance, more compliance, one of the best jobs that you could do for your client is don't create risk, additional risk for him. And that's my goal to achieve. I think that, and I don't have any doubt about that. I don't have any doubt about the independence of the lawyers. Don't have any doubt about the application of the LPP to the lawyers in-house. What I think is that if we want, as the same as the lawyers in the law firms, or the lawyers, the individual lawyers, okay? I'm in a law firm. If in some moment in the time I accept to be manager of a company that is our client, I could not invoke the LPP. It's the same.
Exactly.
Okay. What I think is we could not generate the risk.
And I think there's
One of the, only to end this, one of the situations where I saw a in-house lawyer being really independent, and you'll talk about DPOs after this, and he was fired, was when he refused to be at the same time the legal responsible, and because in his opinion that generated a conflict of interest that put in cause the question of the LPP. And that's the only remark that I want to say. Attention, because in most cases when we have the LPP being challenged, according to my experience in Portugal, naturally, was because we leave the door open in some moment in the time.
And so I think there is a very easy solution to reduce or to eliminate that risk, and that is just hire pure company lawyers. Just don't give them another job. But, and we're really talking about a very, very small segment of a potential profession where a company lawyer or a general counsel in a small company holds also some other positions into the company. I think there we cannot go as far as saying to the authorities, just because he once studied law in his life, he should be covered by legal professional privilege. And you mentioned that as well when you said once he goes on the board, he cannot be covered by legal professional privilege anymore. And this is exactly the same as if a specific person holds various responsibilities. The responsibilities that where he's hired as a legal advisor should be covered by LPP, and the one where he's a janitor should not be covered by LPP. That's certain. In Germany, for example, we've even found a solution to that, which is called Prägung. In Germany, there is some administrative solutions to things, obviously. So when the new company lawyer was established by law in 2016, it also says that company lawyers can only be registered by the Bar Association if the majority of their job is actual giving legal advice to companies, obviously. And with the majority, they don't speak about 51%. Well, of course, there is, of course, an academic fight about it. how much percent it is, but I think it is at rough 60%, 65% at the moment. 2/3. So we have an expert from Germany here. 2/3 needs to be company lawyer work, and then you're covered. You're not covered by LPP, obviously, in Germany,
Nevertheless,
because
you
there
must
is no
prove for
LPP.
that through the timesheet. I don't know if it will be a good solution. The good solution was 100% in my opinion.
Then I have a question, Pedro. How much of your work is legal work?
No, I have, for my clients, 100%.
Okay, so do you write some administrative things? Do you
No,
also
I do
HR?
management in my law firm, but for my
Yeah.
client, it's 100%.
Because
I
we-
don't accept board management. I don't accept nothing of that, even because of that.
But you,
We have in our law firm, it's forbidden for any of the members of the law firm, any of the lawyers, except any of this type of executive.
no, of course, but if you look at and we don't have to talk about you here, we can talk about an average lawyer in a law firm, which I've been myself. And I looked at the work which I performed in a law firm. I can assure you that I did not do 100% of legal advice, because I also did acquisition of new clients. I also did some trainings. You can say that's all legal work, obviously, but pure legal advice was never 100%, because you also have some administrative stuff to do and everything else. And this is what, when I talked about the term of Prägung in Germany, which was the reason why the lawmaker considers this now, because they said, well, obviously there is never 100% anywhere.
Thank you guys for making my life easier. So, Marcos, I understand that there is some controversial about the UA directive to 219, 1937, right? We spoke.
So you're talking about the whistleblower
Yeah,
directive?
yeah.
Okay, good.
So, what's going on with it? Can you enlighten us, please?
Sure. This is a little bit of a technical issue which came up now with company lawyers in one country, especially in Belgium. Well, I don't know if Portugal transposed the whistleblower directive international law. They did. So you're the good kid in class, obviously, because most countries have not adopted it international law yet. They're all behind schedule, and they're working full steam this year in order to have this being done into the national laws. We have a little bit of an issue now in Belgium because, as I said already, in Belgium, company lawyers are covered by legal professional privilege. They're granted secrecy. The whistleblower directive itself knows the fact of legal professional privilege as well. And it grants an exception of that. You have to openly speak about everything to lawyers. And well, as every good directive, it isn't translated in various different languages. For the French version, which the Belgians refer to, this term of lawyers is translated into avocat, obviously. And now comes the speciality, and this is why Belgium has the special way. The company lawyers there are not called avocat d'entreprise, they are called juriste d'entreprise. And the Belgian lawmaker takes this key factor as a reason to say, for the first time since the year 2000, wait a minute, that means they're not covered by legal professional privilege. Where, of course, the Belgian, our Belgian Member Association goes nuts and says, why? Why you actually open this can of worms? Why do you need to open it? So anyway, there is a discussion about this right now, and we're seeking advice by the European Commission now in order to analyze how this was meant to be. There is a little bit of a preliminary opinion around that is not an official opinion that again refers to that dinosaur in the room of Axel Nobel saying, yeah, well, they said it. They're not independent, so they cannot have legal professional privilege, without considering how actually our profession evolved and how compliance systems evolved and how the way we conduct business these days in Europe evolved. So yeah, we're seeking advice now from the European Commission, and we hope to get this advice fairly soon. And of course, we also hope that it is positive for the profession not to open up for putting this LPP under scrutiny again. But let's face it, I mean, as you said already, LPP is nothing that is given for us for lifetime. It's nothing that we should take as granted. We have to fight for this as lawyers every day. We have to protect it as well. We have to obey the rules of LPP as well. And as a fact, we see court decisions in European member states from time to time where we're afraid as well of what's going on in this country at the moment. We had a recent, not so recent, but a recent decision in Germany. Jones Day, I think, was the decision. It was part of this diesel scandal as well. And I spare you the technicalities here because it is really very, very technical. But it ended up saying that the authorities could go into a law firm in Germany and seize all the documents, which from a technical standpoint of view would be, no, of course they cannot do it. And even the German Supreme Court, the Constitutional Court, upheld this decision and said, no, they were right to do it, to seize the documents. So again, we have to fight for legal professional privilege every day and all across Europe.
You? They want to say something to you.
Documents without the judge, without the mandate, a specific procedure, or what?
Again, Max is here as well from as a general manager of the German Bar Association, but it was basically the authorities. I think it was the state attorney of Munich, which is always responsible for economical crimes. They went into this law firm and seized the documents in Jones Day, and Jones Day was hired by Volkswagen to do the internal investigations in the diesel scandal. And then there's 2 or 3 arguments that the court, when they had to review the judgment of the lower court, where they said, no, that was all right that they went into, basically into it. One was that this law firm has not been registered in Germany. So again, it was very technical because it was an American law firm. If I remember correctly, you're not really. And number 2, Max, maybe you want to say something on that. Join us. Yeah, just it's still on.
I was warned earlier that I might be asked to speak a few words about the situation of the legal privilege in Germany. And you mentioned already the famous case of Jones Day. So yeah, I try to just explain quickly the details of that case. So as you mentioned, the law firm of Jones Day in Germany was actually searched, and documents of an internal investigation that was conducted with the Audi company were seized. And the law firm was hired by the mother company, Volkswagen. And this is why the German courts upheld the seizure, the search and seizure of the documents there, because they interpret the German criminal, German criminal proceeding prescriptions as the protection of the legal privilege is only between the lawyer and the accused in a criminal proceeding. And the accused in that case were managers of the Audi company, of the subsidiary, but the mandate, the law firm was hired by Volkswagen, and that is why, the seizure was approved, let's say, even by the German Constitutional Court. And as of now, this case is pending at the European Court of Human Rights. So we are also, as an organization, are hoping for the European Court of Human Rights to actually correct this decision, because we obviously do not agree with that interpretation of the rules of criminal procedure in Germany. And generally in Germany, we see that the legal professional privilege is under constant attack in terms of and anti-money laundering provisions, as well as tax-related investigations, and now recently the jurisdiction on the criminal procedure. If you want to for me to also give a little detail on the situation for in-house lawyers in Germany. From what I understand from our conversation yesterday, Duarte, is that here in Portugal, in-house lawyers do have to register to the bar. It is mandatory. That's not the case in Germany. It's not mandatory. However, it's possible since 2016. You mentioned the new regulation that enables in-house lawyers, if they predominantly work as lawyers within the company and give legal advice and legal representation, registered to the bar. Now, in that case, the rules for the legal, the professional rules, generally apply, and that also includes confidentiality. So the in-house lawyers do have to keep their matters obviously confidential, but of course the most interesting, most important part are criminal investigations conducted by the state attorney, the prosecutor, and in that case, and also in the criminal proceedings in court, in-house lawyers do not have the privilege. Only in civil case, in civil law proceedings, in those situations, they do not have to testify and are more protected. So yeah, that's in a nutshell the situation in Germany.
LPP is not the problem of only the in-house lawyers. It's a problem that affects all. And well, I was listening to this experience. We have similar here in Portugal a few years ago, and we have one that was worse. One of a colleague of us that refused to give the documents to the prosecutor, and it was immediately accused in the law firm, and that was a very noticed case here. Okay, we all have attacks regarding the question of the LPP. I will say that is the way of the new times that we have with regulation, with compliance, whatsoever, and that's one more reason to be more careful, to don't open that door to create the worst problem.
Exactly, I couldn't agree more. I mean, we even saw it in the US. I think a couple of years ago, there was this Marriott case where documents were also seized in the legal department, and that was even upheld by courts. But because of the argument, they were giving business advice, not legal advice. So we have to be very careful, and we have to be vigilant there in order to protect our clients' rights for LPP and for secrecy. Yeah.
It was very, very interesting to hear this discussion between you two. Now I'm going to open to the audience and ask if there are any questions. I see one there. Yeah, of course you may.
Regarding legal privilege in Portugal, it's true that there is legal privilege and there is no distinction between internal and external lawyers. However, in Portugal, a law firm or internal department of a GC in a company can be searched if the lawyer is a suspect. Okay, so what's happening in Portugal is, from 10 years maybe, is that the authorities, the public prosecutor, makes the lawyer a suspect, formally a suspect, says you are a suspect. And sometimes we ask, what's the suspicion? The suspicion is that you are a trusted advisor to this other suspect, which is the fundamental of being a lawyer, right? It's trust. And so, as Pedro was saying, although we may have a good law in protecting LPP, the truth is that everyone is going around it. And we must take action. We should take action together in the EU, like you said, Marcus, against this, because otherwise our profession gets much more weak.
We have this in Germany as well, obviously, that if the lawyer becomes subject or becomes the accused, then of course they can be searched as well. But there is another bar to it in Germany, fortunately, because not the local courts or the local state attorneys can decide to go into a lawyer's office. There's a very high barrier to that because you always have to go to the office of the federal state attorney, and only he can allow the police to go into a lawyer's office in order to have a search warrant. So only he can give it.
Anyone else? Well,
I was reflecting on the conversation you had earlier about sort of the mix of work, the legal, strategic, commercial work that we do day to day as in-house lawyers, and whether that threatens the protection of privilege. And I wonder if it's perhaps not helpful to think about it as percentages, you know, what percentage of your work is legal and what percentage of your work is commercial, because that changes day to day. And it's quite an artificial exercise, I think, to undertake. And I wonder if the better approach is to accept in principle, ideally, at least, that in-house lawyers qualify for privilege. So that's the principle, or it should be. Whether in a particular case that protection exists will depend on the facts. So if, for example, in the context of a criminal investigation, authorities seek to seize privileged documents, then at least in England and Wales, the test will be what was the dominant purpose of the documents. And if the general flavor of the documents is advice, then privilege will apply to the whole document. That will be a case-by-case inquiry, because I think if you apply the principle that, oh no, I'm a 90% business lawyer and a 10% legal advice lawyer, then that's a slippery slope. And I think some lawyers who work in some areas might then not qualify for privilege at all. So I would prefer a more of a case-by-case approach.
Even if you have the LPP, I am a lawyer, I have the LPP, but I am a manager of a company. In that case, I don't have the protection. That's the way it works. You have the right, and the case, that's what was told before also, you need always to do the analysis case by case and situation by situation. It's even if you don't work in commercial or thing like that, you are only a lawyer 100%, you kill a guy, you don't have LPP on that. It's clear, no? It's not a question.
I couldn't agree more with what Peter said.
okay. Anyone else? Okay, this was brilliant. Thank you guys thank you, Peter, Marcos, thank you, Pedro. I was translating your name for all your knowledge and the way you communicate. So it's clear that we must fight every day for LPP. So we are all together in that. And now we would do a 10-minute break and then begin with the second panel. Thank you once again. Thank you. Thank you.
So good afternoon to everyone. Thank you for being here with us. And since we are broadcasting or recording for those who are at home or in office, I would like to welcome our colleagues also from there or from which platforms they are attending this conference. Before I introduce our guest speakers, to whom I congratulate and thank you for accepting the invitation, I would like to say that the choice of the team for the Institute, for the company and association lawyers of the bar, Portuguese Bar Association was completely conscious, because actually we know that today, today's markets will dictate some rules, important rules. And just as we speak, I'm aware that lots of our colleagues are just raising the question either to accept or not to be DPOs. And it's not an easy decision process to take, because it has so many duties and tasks and conflicts of interest and independence issue. So we should all be raising awareness about this and not just and not stepping aside this kind of challenges for us. And as we know, actually 2021 was a year of full impacts on new actions and new laws about protection vector. And I believe that 2022 will also be a very defining year on this matter, because, you know, we don't have only one law, we have several laws regarding the protection of personal data for citizens. And so we must be deeply conscious of the imperative of public interest that we are dealing with. And so that being said, I will pass through my first guest speaker that made me the favor to handle me his brief CV curriculum. So I will introduce you. David Rubin from ECLA. He's the General Counsel. Thank you once again for accepting the invitation, David. And he graduated from Stockholm University in the beginning of 2016, and since then worked within financial industry, mainly focusing on the Swedish Nordic markets, but also working internationally. For the last 5 years as General Counsel and part of the management team of the publicly listed investment bank Mangold. Am I saying correctly there? Yes, okay. Core responsibilities includes corporate governance, international mergers and acquisitions, and general business legal advice. Deputy Chairman of the Board of Directors for the Swedish Company Lawyers Association, now for 4 years, the mandate, okay, and multiple board positions for both private companies and nonprofits. Highlighted as leading in-house counsel and future leader on numerous occasions by organizations such as Legal 500, and Nova Talent and the Wallenbach Foundation's Tandem Leadership Program. So I'd like to express my gratitude, and now David, please, you have the floor. Thank you.
Firstly, I would just like to thank your organization for firstly hosting our ECLA General Assembly and also this event, and for me being able to speak here. So I could just tell you my side of the DPO role. As of right now, I'm not the DPO of Mangold, but when we started the project, I was the project manager, and for a period of time, I was the DPO. Then after a while into the project, we realized that me being the general counsel and in the management team, that it wasn't really a good fit for us. And I think that stems from us being a financial institute. We already had that type of separation with our compliance department, which is completely independent. And we saw exactly the same arguments for the DPO role to be the same. So we actually transferred that role to the compliance department. And just to give you a little bit of a flavor how I view the DPO role, I'd like to just describe how we looked at the project and how we saw it. So we actually handle it. I think it's quite easy for us as a financial institute to implement this, because it bears a lot of resemblance with the compliance department and how they work. So what we did is that we actually did 2 gap analysis, firstly against the old Swedish regulation, And then we did the one against our company's internal processes and how we're handling things. And then we started to fill out the gaps. And also, before we actually started the implementation project, we also did a risk analysis, which is quite common in the compliance world, where we also could focus on a risk-based approach. So we can focus on the biggest risks and start to close those. And then along the way, we started to go down to the smaller parts. And then it's basically just an ongoing project. And as we see right now, the regulation, every time there's a new regulation, there's going to be a time when you have a lot of uncertainty, especially in the beginning. And you just really need to follow the legislator, follow the practice that comes out, and try to tighten everything. So that's basically what we've done. And also, there are a lot of good tools. You have the GDPR, I think it's called enforcement, or something. It's a web page where they list all the sanctions from every different EU country. And if you can follow that, then you can see and learn from other companies' mistakes, and a lot of authorities as well. That's been the main focus in Sweden. So that's a little bit how I see the DPO role.
Thank you, David. Maybe I'll introduce now our second guest speaker, Tiago Felix da Costa. He's graduated with law degree from the Lisbon School of Law, and also holding a master's degree in law from Católica Lisbon School of Law since 2009. He also presents postgraduate studies in corporate law, and further, he holds the advanced training course on data protection compliance by the EU or European Institute of Public Administration. He has been practicing law since 2004 in a leading Portuguese law firm, Moraes Leitão, the year of his membership at the Portuguese Bar Association. Since he has been heading several legal teams regarding criminal compliance and data protection matters, I think it's an honor to have our guest here today. Thank you. And also he has a wide experience in areas of criminal, regulatory litigation, civil, corporate, commercial litigation. And in particular, when we're talking about personal data privacy and protection, Tiago is active in personal data protection field, providing legal assistance on criminal and regulatory processes in this area, and also assisting several companies on the creation of policies and programs of compliance in the field. Also, from 2009 until 2018, Tiago was a guest professor at Nova School and often teaches several advanced and postgraduate courses in his area of practice. Last not least, in 2017, he's received the Under 40 Award organized by the Iberian Lawyer. And in 2019, Tiago was nominated Client Choice, exclusively for Portugal in the category of litigation. Also in 2021, he has been distinguished by Legal 500 as a leading individual, both on criminal and data protection practices. So I express my gratitude. Thank you. You have the floor.
My pleasure. So regarding being a DPO and the relationship between DPOs and lawyers, there has to be a clear distinction between internal and external lawyers, because I believe that the problems that may arise are different, but on the forefront, we have to understand what the DPO is. And basically, the GDPR changed the legal framework regarding data protection, especially because the European legislator changed a system of hetero regulation for and implemented a system of self-regulation. And the way I see DPO is a way that the EU legislator tried to smoothen the transition between these two paradigmas, because the DPO, and this is the way I see it, the DPO is like a special a special internal audit. So it's someone that has to be independent and has to be knowledgeable of both the organization and also of the laws and the legal practice around data protection. So the questions, Filipa, thank you once more for your invitation. The questions that arise must start on understanding. Of course, we all understand what being a lawyer is, but I believe that DPO is a relatively new figure in our legal systems throughout the EU, and we have to understand first what a DPO is, and then to check whether or not lawyers can be or can act as DPOs.
Okay.
Yeah. If you want, I can go into the problems.
I think that it's clear that being a DPO is quite a difficult decision to take because even you are in a senior management position, you have to take responsibilities. But if you low down the position on a specific organizational structure, if you are self-monitoring your tasks, you will always have to comply with data protection. So I believe that the interesting part from this conference that we can deliver to our colleagues who are attending the content, and I really hope we will deliver for a very positive impact for this, would be to get into some more practical details, as you said. And David and Tiago, please, I would like to explain to us, if possible, what are the risks that our colleagues, that lawyers in-house, lawyers who are DPOs, lawyers who are DPOs to be, because even if you are not a DPO, you need to understand the language and you need to understand the questions that are being raised by the DPO within the company. So you need to quite be conscious about the public interest that is at stake. So in your opinion, if you were a lawyer who's having a job offer or a service offer about being a DPO, would you take it for granted? Would you accept it without expectation? Or would you first went to check on the guidelines and see if you have appropriate levels of insurance, liability, not being afraid of being threatened, because there is, of course, the mandatory reporting for DPO. So how would you, what was the best practical advice you could give to our colleagues at home when facing this position and this decision-making about being a DPO or not being a DPO? Thank you.
Yeah, I can start. So what I would look at, and firstly, it's going to be the common lawyer answer, and it all depends on the company and the sector and the management. But what I would look at if I was offered a DPO position is actually how the management view these type of questions, and if it's a value thing, and if we're going to put in the needed resources to do this in a good way or not. Because in my opinion, it all starts with the tone at the top, and that's gonna set the structure for you to work within. So if you have, for example, a CEO that doesn't care about this and just think it's a waste of money, then you're not going to get the tools to be successful in that position. And also, if you have the tone at the top, it's also depending on the company and the staff itself. Because one thing that we saw, because we can do, in a project perspective, we can do all the things, we can do the analysis, and we can implement the right routines and structures. But if no employees follow, then it doesn't matter. So a big part, which we realized, is the training, and to get this in the mind of everyone, because we want our project managers, our wealth managers to have this in mind when they work. I mean, we really focused on putting that in there. So there's always, in everything you do, we have this type of aspect, because with this new regulation, or not new anymore, but with the sanctions that could be implied, it's a real risk, which we can't afford. And therefore it needs to come down. Both needs to start on the top end, but it needs to come down. It doesn't matter if you're the CEO or you work in the reception. Everybody needs to bear this in mind. And I really mean that because it also depends on which question it is. Sometimes it is the reception that has some type of risk. We run into something that sounds really simple, but a list of allergies for all the employees. That's sensitive information, and you can't handle that in a special way. But so that's basically what I would look for.
Let me just add that another ingredient is that we are now in the intersection between tax and laws. So this comes as a more difficult task because somehow the commissioners, the council, the MEPs, we're talking about creating a law function which acts as mixed law with technology trends. No, Tiago?
So I'll try to make two important distinctions. One is we have to consider the legal issue. Can a lawyer be a DPO? Can a lawyer act as a DPO? And then the practical approach. And I will share with everyone my own approach. But the legal question is, can a lawyer act as a DPO? And you have to, of course, make the distinction between internal and external lawyers or counsels. But I see this question a bit as the questions that my three-year-old daughter makes me frequently. That can I be a unicorn or a mermaid? And I say, of course you can. Of course you can be a unicorn or a mermaid. But as in these questions or in these answers, there's a number of buts. Yes, you can be a unicorn, but you cannot fly. You can be a mermaid, but you cannot breathe underwater. And so it's the same with this question. Yes, lawyers can be or can act as DPOs within a certain organization, but there are a number of buts. And for my perspective, of course, I'm a little bit limited by my own Portuguese perspective, but I guess it's the same throughout our systems, is whether or not there is an impediment to act as a DPO. According to the Portuguese bar code, I don't believe there is an impediment to act as a DPO, but as always, there may be conflicts of interests. And there are a number of situations where these can arise. Let's imagine. First, the DPO, according to the GDPR, the DPO is a point of contact with the data protection authorities. Let's imagine that the data protection agency is asking questions to the DPO. As a lawyer, if you think, well, I may not answer everything that I know, right? Because I'm protecting my client. I'm not obliged to tell the truth to an authority. I'm not even obliged to tell anything to them. But as a DPO, I'm answering before a public body. So if I don't tell them everything, I may be committing a criminal offense. Other cases, let's imagine that you are acting as a DPO and there's a lawsuit against the company about a data breach. And as a DPO, you issued your own opinion about the matter. The company followed your opinion, but there is a data subject that is fighting the decision of the company, for instance, not to inform the data protection agency or not to inform the data subjects affected by this data breach. What will you do as a lawyer? The company asks you, you go there, you know the problem, you participated on the management of the data breach, now you can act as our lawyer. And I say, well, I don't know if I can. Why? Because I may tend to defend myself because I provided, as a data protection officer, I provided guidance and advice to the company. And now the company is being sued because of my advice. Can I act as a lawyer? Doesn't seem so. More, can I be a witness? So I'm representing the company and the other party calls the DPO to testify. What shall I do? At least according to the Portuguese system, I don't know others, but lawyers cannot be witnesses in the same lawsuit. So there's a number of problems of legal issues, I believe that, of course, lawyers can act as DPO, both external and internal lawyers. There are some slight changes on the type of issues that may arise about this, but there are a number of buts. And my personal approach back in 2018, a number of clients. So I work on a law firm. We work with big Portuguese companies mostly, and some international companies. And some of them ask, there is this new thing, DPO. Can you act for us as DPO? I said, are you sure that you want me to act as DPO? I know your company. I'm obliged to send my opinions, my guidance directly to the board. So I will put the board, my client, in a tough position because I know the company, I know the areas that are not compliant with the GDPR, and I have a duty, being a DPO, I have a duty to inform the management of the gaps that David was mentioning. And if they don't correct the gaps, basically they are infringing the GDPR. And at the same time, I'm helping me, a DPO and a lawyer, I'm helping the authorities to prove the intention to disrespect the GDPR. So my approach is I've never been a DPO. As far as I can tell, only one case in our law firm, we acted as a DPO. And for these type of law firms, I do not recommend lawyers to act as DPOs. But I believe that from my experience, and I work with several DPOs, being a lawyer can be an important background for a DPO. What you cannot do, or at least what brings problems, is if you try to act at the same time as a DPO and as a lawyer. Because let's imagine this, being called as witness and trying to act as lawyer at the same time. I would be ashamed, actually. I would be embarrassed of putting myself in that position. So for me, personally, it's not an option, but of course, I believe that lawyers should, if they are invited to take that position in an organization, they should consider it, because I believe that lawyers are in a very good position. I believe it's easier for lawyers to be DPOs and then to learn the technical stuff that they need to learn than the other way around. So tech people, IT people become DPOs, and then it takes a long time to understand how the system works, and they struggle a lot. They also can get there, but they struggle a lot. Thank you.
Yes, that I totally agree with you. The thing is, what I saw, like when this came, and the trend was when it was all new, we had a lot of law firms starting, actually just focusing on GDPR questions and also taking on the responsibility of the DPO. But now when it's been a couple of years, we're seeing that declining a little bit, in my opinion. And you see them exactly like you mentioned, you see that you need to bring it in-house and also gaining the technical knowledge and expanding that. And from my view, coming from a company side, what we have done is that we have a lawyer, we segregated it to the compliance department, so it's totally independent, but we also supplied him, because what we realized that we can't have a lawyer that's also a technician and knows everything IT. But what we do have is that we have a great IT department. So we put together a team to help him. So he has someone to ask questions and try to figure out the solution, and they do that together. But he's driving it, and he's taking charge. So I totally agree. I think it needs to be a lawyer. But I think if you have the possibility to segregate it, I think it's for the best. But also, I've seen other companies. It all comes back to, it depends on the company, what you do, and how you're structured. Because I've seen some cases that has found it successful, that you have maybe the general counsel as a DPO. But it all depends. And in our case, which is the only thing I can talk about, is that we saw it necessary to segregate it.
Main problem is the independence not of the lawyer but of the DPO, because, for instance, I'm a general counsel, I have a team, let's imagine, and acting as a DPO, I have to, for instance, to apply the minimization principle, but I don't want. As a GC, I want more information. I want to go after the guys that are owing my company, and so I want more information. But at the same time, as a DPO, I should have less information, and so that's difficult. The ideal system, in Portugal, I believe it's very rare. I don't know if I know one case, one or two cases, but the ideal system is to have a DPO or a DPO team, whatever, and also a privacy team. So lawyers specialized in data protection, and also a DPO, because what happened here in Portugal at the beginning with big companies were that the DPO was at the same time a privacy expert. Okay, but it doesn't work. Because as a lawyer, you can say to the company, well, example, asking for consent should be the legal ground to do these processing activities. And the management will say, well, consent, we will lose 2 million clients. No, it doesn't work. Okay, so as a lawyer, you can say, okay, you don't want that, but you have another solution with a bit more risk. The DPA, the Data Protection Authority, may not like it or may disagree with it, but you have this solution and it's okay. As a DPO, you shouldn't do this. You should issue your opinion and send it to the board and say, this is not, the legal ground should be consent. And so ideally, in large organizations, you should have lawyers, specialized lawyers in data protection or in privacy, and DPOs. In most cases, this is, at least in Portugal, almost impossible. So as you were saying, you have to find an independent function like compliance, and the DPO sits there. And I believe it's difficult after that to act as lawyer for the company. On privacy matters, of course, if your colleague that is now a DPO tomorrow is a lawyer specialized in, I don't know, antitrust, no problem. So the conflict may arise when you are acting as lawyer or representing the company in a lawsuit related with data protection, and you were a DPO as well. That's I believe that's the main challenge.
Just to add, I think you stumbled upon something really important, and where we have find the magic within all of this. When we separated it, you have the DPO section, who can be hard in his opinion, but you also have me on the legal side, and the discussion. The company comes from one side, they want to do something, the DPO says no, but then I come in and we start to negotiate, and I try to twist and turn and find a solution. And that's basically where we find the best solution, in my opinion. And that's been really successful for us. And I'm happy that we have the possibility to break it down in this way.
If you are a specialized auditor, and I believe a DPO is a specialized internal auditor, and you focus on the criteria of the Data Protection Agency, at least if it was the Portuguese agency, your company should close the doors, because almost nothing, you can do nothing. And so that's the way you find balance. It's to understand that the business have to carry on, and that the data protection must be complied with.
Okay, after I open the floor to the audience, maybe you are thinking about some questions to raise on this tricky matter. I cannot resist to tease you a little bit, because in a general way of speaking, when this single law came into force, it was supposed to stop the national fragmentation of several protection laws, but also it was supposed to eradicate administrative burden. And sometimes when I look at all the regime for DPOs and the GDPR in itself, I wonder, it's a question, if we are not opening the information, private information, transferring it to, well, say, independent law firms or independent tech firms or independent, not in-house lawyers. So in order to keep privacy, are we not in a paradoxical way making it more open wide? And at the end of the day, are we doing the best job we can to protect people's data?
Well, I'm being a lawyer now, as David said. It depends. Depends the way you do things. I believe that technology, at one hand, may harm privacy, but at the same time, it's the best tool to protect it. So I believe that it's a question of your attitude or the organization's attitude towards data protection. One thing, but this would be another discussion, is that in the beginning of your question, is that the number of obligations that EU companies have to comply with are not helping us to thrive when compared to the US or Asia companies. But that's a different question or a different subject. I believe that GDPR is legislation trying to keep the fundamentals of the EU according to our culture, but at the same time is not sufficiently open to, to help companies thrive in a global market, because it depends a lot on the authorities. In Portugal, we have a strict authority. In Spain, perhaps even more stricter authority. In other countries, a bit more open. It depends a lot.
No, I agree. I have a little bit hard time seeing GDPR really helping with data protection in the way it's supposed to be. I see the benefit of it, making it easier to operate in Europe, but as you mentioned, it all depends on which country you are in. And if you watch the sanctions that have come out, it really differs which country you see. For example, in Sweden, the authority are mainly focused on government agencies, and it hasn't really affected company. Now they've started, and then you see they focused on Klarna and give them a big sanction. So now all the companies within that sector is becoming a little bit nervous, because it feels like they're going on a map, basically. So they're going to do sector by sector, but you don't know. What I think is interesting, and I think it's a development from this, is when there's coming new legislation regarding privacy and artificial intelligence. That I think is really interesting. We don't work a lot with artificial intelligence software, but I know you mentioned, but a lot of Asian companies, American companies do that, and I think that's going to have a real effect, and that's where you're going to see, I think, the biggest challenge is also how you're going to do this, because you're starting from the tech, artificial intelligence in itself is complex, and then you try to make legislation about that. I don't see how they're going to succeed, but it's interesting to follow. I hope they do, but also, it's just going to be an interesting development, and I don't think it's going to go away. I think it's going to take some twists and turns, but I think you just need to try to learn from other people's mistake, and try to always talk to colleagues, go to these types of events, and try to be knowledgeable and always developing.
So thank you for sharing your insights. I think it was very positive. I hope that every colleague in DPO's function at home is feeling a more clear or certain path to take on. And now I will open the floor to the audience for those who want to raise some question, please. Is there anyone would like to clarify some question on this topic?
Thank you. Yes, I was wondering, perhaps Tiago, could you give us an overview of the way that the Portuguese regulatory authorities are enforcing in this area? Because we heard a bit from David on Sweden. Yes, yes. How's the enforcement going? Are they doing the same technique, sort of starting with government and going to sector by sector? Would you characterize them as being lax or incredibly aggressive?
In harm's way. In Portugal, we have a problem, is that the Data Protection Agency and we have a data protection laws since 91 and even before the 95 directive, and it's in our constitution since 76, the fundamental right to data protection. The problem is that our governments, whatever the political flavor, they are not very fond of the Data Protection Agency. They see it as an embarrassment to the public administration life, and so they don't provide enough funding to the Data Protection Agency. So it's a very small agency struggling with the lack of resources. At the same time, it's in the European Data Protection body, the former Article 29. It's I believe an important institution because they are there from the beginning. But what they are doing is they are reactive. So we are not seeing that. For instance, choosing economic sectors where you know that there are more risks or that pose more risks to data protection. And I will not say any because I have several clients from within those sectors, but I believe it's obvious, and we are not seeing that. For me, it completely makes sense that Data Protection Agency, as one hand, provides guidelines, and ours does not provide guidelines, at least workable guidelines for a number of months now. And it's not very data protection agencies, like, for instance, I don't want to be too unfair, I don't know all of them, but as the ICO in the UK is friendly of the business. So it's the Anglo-Saxon way. So they provide a lot of guidelines. They are very you even can chat with them online and ask them questions, and they will get back to you, etc. And when they come and see that you are infringing the law, you have a big fine. But usually they provide a chance and say you shouldn't do this like you are doing. You have a number of months to get yourself together and comply. And then if they understand that you are not complying, they will give you a hard time with a big fine. Here in Portugal, it's the opposite. So they are reactive. They are not approaching sectors. And we had a number of media cases where big data breaches occurred. I cannot talk about them, but and then they act, or they have complaints data subject saying, I'm getting these marketing emails and I have opt out, and the company still sends me. And so they will start a litigation against the company because the company infringed our e-privacy law. So that's the way it's working in Portugal. Unfortunately, I believe it has nothing to do with the people there, but with the lack of resources. And that's, as Filipa pointed, so the GDPR should provide a level playing field between countries, but actually it's not, because one authority is more resourceful than other, and so one is more friendly to the business. When I say this, is the businesses need guidelines, right? You know that you can do this and then you cannot do that. That's okay. When you live in uncertainty, it's not good for businesses. And in Portugal, it's a bit the way it's going.
So anyone has some thoughts on this, or some tools for thoughts at least? Any questions? Were we sufficiently? Yes, one. You can have the mic, please.
Okay, can you hear me? Yes. Okay, now thank you first of all. Very interesting. Now, my question is on a common headache for whoever is dealing with this subject matter, which is the international transfer of data. And I'm referring to the situation of personal data exchange with non-EU countries or non-EEA countries, okay? Because I think this is something where the DPO stance is maybe strict, and where the companies, on the contrary, maybe the General Counsel has to provide more effective advice, pieces of advice which we enable to overcome an objective obstacle today, because it's the legitimate interest or the legal ground to export or import data, personal data with the US, for instance, no? And the privacy shield is dead. Is not. There's nothing yet. We know that the President Biden signed an executive order, maybe recently in September. Okay, is a step forward, but still there's a great deal of uncertainty on what the companies can do or cannot do in this respect. So I would like to maybe listen to your opinion on this headache, and whether you have aspirin, you call it aspirin, or something which will help you to remove your headache, you know, from your mindset. Thank you.
I don't know.
Well, actually, it's a big headache because, in my humble opinion, today, data transfers for the US are or seem to be illegal, because you have the Schrems II decision, basically saying that the standard contractual clauses are not enough. And then you have the EDPB 6 steps, I believe, for compliance with data transfers. But they don't solve the problem, because basically well, everyone exchanged data with the US. It's almost impossible for a medium to large organization not to do it. Just think about Windows, Apple, etc. And the way things are right now is you cannot change the US legislation. And the problem is only the fact that some authorities in the US have the right to have access to the data exported from the EU to the US without a court order. That's the problem. And so when I call the Portuguese data protection agency, call because they don't have guidelines. Okay. So I call them and try to speak with them, or at least in conferences, and I try to get their opinion. They say, it depends. So what can I do? You can do some, you can take measures to ensure compliance with the 6 steps that the ADPB issued. But what measures? What can I do? Encrypt? But encrypt, they have to be decrypted there because they are working on it. So I don't know. We don't know. It's the company that has to find a way to apply mitigation measures. But specifically to the US, there are none mitigation measures, because the problem on Schrems 2 is that the European Court believes that there is not a reasonable level of protection for the EU data, because authorities there can have access without a court order. What can I do to minimize the risk of this happening? It's very strict, and it's again, it must be good to be a legislator, because you don't work with the problems. Because I have that headache, because clients and some of them DPOs ask me, what shall we do? We have millions of data going to the US. Standard contractual clauses, yes, we have them. Privacy shield, yes, no, it doesn't work anymore. Safe harbor before, now we have privacy shield, doesn't work anymore. And if there is another privacy shield, Mr. Schrems will go again, and the European Court will go again and say it's illegal. And so it's a bit of I don't know, people that are not working every day, because if you are acting as a DPO, what should you do? Inform your management. Imagine that you are a DPO for a bank, and you issue an opinion to your CEO saying, data transfers for the US have to end. So wire transfers to the US cannot happen under the SWIFT or other mechanism. So thank you for the question. It's a hot and hard topic, but it's the way it is. It's for me, it's almost easier to send data to Russia right now than to the US.
I can just add on. Firstly, working in the financial sector, we're a little bit lucky that we're covered by bank secrecy law, so we really had a tight grip on our customers' information. But as you mentioned, some cases going with SWIFT transfers, different type of transactions, you can't really avoid it. But what we did, one of the issues in this regard for us was we had servers abroad, and thankfully, our CEO and the management, they're really listening to these type of questions. So we basically took the big decision to move everything, and we changed a lot of vendors just to fit into the legal framework. And I think for me, I try to be as practical as possible, and most often the simplest solution is just to abide totally. So that's what we're doing in most regards. But then also, I'd like to point out that there's also, in some regards, you can't, and there you really need to, and then that's also where the separation of the DPO role comes in place, because they need to be able to say no, but then you need to be able, on a management position, to say yes if it's too big of an infringement. Because I don't know who said it, but the safest deal to do is the one you don't do, and it's something to that. But then we wouldn't have any jobs. So there's also something, and it's always that balancing act and see where you get. And in the end, it's a management decision, and some risk you maybe have to take, as long as you do it with everything in mind and taking everything into account, and you manage the risk as good as you can. But sometimes that's it. You just do as good as you can, but you have to leave it with that. So that's basically it. Yeah.
So I think we'll have companies quite busy with this topic during, well, all these years. I think you have spoken wisely and I pay tribute to your efforts. Thank you. I don't know if the audience has any questions. No, we are reaching our times now. I think every colleague at home is now, well, certain that it is a difficult task to even to decide to be a DPO or not. So at that level, I think we reach our targets to make their heads, without aspirin, actually, will make their heads ache a little bit. But I really hope we have deepened our understanding about the complexity of the theme. And I would like to thank our staff for the excellent organization of this conference. Also, Duarte is here representing the General Counsel of Portuguese Bar Association. And of course, President of ECLA, Jonathan, thank you. Marcus, thank you very much. Our guests, of course. And I would like a special thanks also to my team, to Marta and Paulo who are here from the Company and Association Lawyers Institute from the Portuguese Bar Association. It was a pleasure for me to conduct this. Thank you so much. And well, we'll stay in touch for this. Thank you.